Your basement was legal on Tuesday. By Friday, 5 separate sections of code turned it into a crime scene. Nobody knocked on your door to tell you. Nobody sent a letter. Nobody updated the prepper form you bookmarked in 2019. The law moved while you were stacking cans, and now the same shelf that made you feel safe is the same shelf a prosecutor would photograph and label as Exhibit A. I am Raccoon Survival. I read the codes you do not read. I read them because I have watched too many otherwise smart people walk into a courtroom with a defense built on common sense and walk out with a misdemeanor on their record because common sense does not appear in the index of any state statute. Today we are going to walk through your basement together. Not the romantic version your favorite influencer sells you on a 30-second clip. The real version. The version where 5 everyday prepper categories have quietly become illegal in jurisdictions across this country, and where the gear you bought with your own money on the open market is now, depending on where you live, a violation waiting to be discovered. Before we go down those stairs, I want you to understand who sold you the lie. The survival industry. The tactical brand ambassadors with the discount codes. The blogs that write the same 5 gear lists every year. The forums where the loudest voice is usually the one with the least field experience. Every one of those channels operates on a single assumption, that the legal environment in which you bought, stored, and used your gear is the same legal environment that will exist when you actually need it. That assumption is a fairy tale. The legal environment is not a static room, it is a tide. It moves on a schedule that is not yours, written by people who have never met you, signed into effect by governors who have never seen your zip code, and enforced by deputies who do not care that you stocked up before the rule changed. The grandfather clause you are counting on does not exist in most of these statutes. Read that again. The grandfather clause you are counting on does not exist in most of these statutes. So here is what we are going to do in the next 40-something minutes. I am going to lay out 5 categories of prepper activity that have, in real, measurable legislative time, become regulated, restricted, or outright illegal in specific states and cities. Every claim I make tonight is anchored to a real statute, a real ordinance, or a real federal enforcement action. I will name the bill numbers. I will name the code sections. I will name the municipal ordinances. The sources are in the description. This is not a feeling. This is a paper trail. And by the end of this episode, you will have a weekend assignment that could keep you out of a courtroom. The last category on this list is the one most preppers have never even considered, and it is also the one with the most aggressive federal enforcement record. So stay through to the end. Now, before we open the arsenal, we need to talk about the doctrine, because if you do not understand the doctrine, the 5 categories will sound like 5 random complaints. They are not random. They are the predictable output of a single mechanism, and once you see the mechanism, you will see it everywhere. I call it the doctrine of state escalation. It works in 3 steps, and it works the same way every single time. Step 1. A federal agency declares. The Environmental Protection Agency, the Bureau of Alcohol, Tobacco, Firearms, and Explosives, the Federal Communications Commission, the Department of Transportation, the Federal Emergency Management Agency. They publish a rule, a guideline, a memorandum of understanding, a model code. They do not arrest you. They are too far away. Their job is to set the temperature of the water. Step 2. A state legislature applies. The State House picks up the federal framework, repackages it as a bill with a friendly name like the Public Safety and Resource Management Act, and passes it in a session most voters do not follow. The governor signs it. The bill becomes a chapter in the State Penal Code or the State Administrative Code. The fines are written, the criminal classifications are assigned: misdemeanor, felony, civil penalty. Step 3. A county sheriff enforces. The deputy who shows up at your door does not work for the EPA. He does not work for the FCC. He works for the county, but his arrest authority is the state statute, which was built on the federal framework. The federal declares, the state applies, the county knocks. That is the chain. Memorize it. because every one of the 5 categories we are about to walk through is a perfect example of all 3 steps. And here is the cruelty of the system, the part the influencers never explain. You do not get notified at any of those 3 steps. The federal rule is published in the Federal Register, which almost no civilian reads. The state bill is debated in committee hearings that air on a public access channel at 3 in the afternoon. The county enforcement is a memo in a sheriff's department training packet. By the time the chain reaches your front door, you have been a violator for somewhere between 6 months and 3 years, and you did not know. The prosecutor does not care that you did not know. Ignorance of the law is not a defense. It is, in the prosecutor's filing cabinet, the gift that keeps on giving. Now we go down the stairs. 5 categories, each one a real statute, each one a real risk, each one solvable in a weekend if you actually do the audit. The first category is rainwater harvesting. I know, you are already laughing. You are thinking, Raccoon, surely the rain is free. The rain falls on my roof, runs into my gutter, and drips into a barrel I bought at the hardware store for $49. Surely no government on earth is going to tell me I cannot collect water that fell out of the sky onto my own property. Stay with me, because in large parts of the American West, water rights doctrine does not work the way your intuition works. Water in those states is not yours just because it landed on your roof. Water is a resource governed by a system called prior appropriation, and prior appropriation says that the right to use water belongs to whoever first claimed and put it to beneficial use, regardless of where it falls. That farmer downstream with a water right that dates to 1894 has a legal claim to the water that lands on your roof in 2026. That is not a metaphor. That is the doctrine. Colorado spent decades treating residential rainwater harvesting as a violation of senior water rights. In 2009, the state legislature passed Senate Bill 09-080, which finally created a narrow legal exception for residential rooftop collection, but only under specific conditions involving the size of the parcel, the source of the household water supply, and the volume collected. The default in Colorado before that bill was illegality. The default in Colorado after that bill is conditional legality. If you do not meet the conditions, you are in violation. Most homeowners in Colorado who set up a rain barrel today never read SB 09-080. They just assume the rain is theirs. It is not. It is theirs only within the 4 corners of the statute. Utah took a similar route with House Bill 36 in 2010, which legalized small-scale rainwater collection but capped the volume at specific limits, and required registration with the state engineer's office for anything beyond a token amount. Read that sentence again. Registration with the state engineer's office to collect rain in Utah today. That is not a hypothetical. That is the current state of the statute. If you live in Utah and you have a 2,000-gallon cistern set up in your backyard for emergency water storage, and you have never registered it, you are operating outside the framework of HB 36. Whether anyone notices is a separate question. Whether you are technically in violation is not. Oregon takes the doctrine even further in some interpretations. Oregon water law treats rainwater that has touched the ground as part of the state's surface water system, and a series of enforcement actions over the last 15 years have made clear that large-scale residential collection, particularly anything that diverts runoff from natural drainage paths, can run into administrative penalties from the Oregon Water Resources Department. There was a case out of Medford in the early 2010s involving a man named Gary Harrington who was prosecuted for collecting rainwater and snowmelt on his rural property. He served jail time. The case was complicated and involved more than just rooftop barrels. It involved large reservoirs and a long history with state regulators, but the case became a flag in the prepper community for a reason. The reason was simple. The man went to jail for collecting water on his own land. Whatever you think about the merits of his specific case, the legal reality is that water collection in Oregon is not a default right, It is a regulated activity. So what is the typical mistake the crowd makes here? The typical mistake is the assumption that a hardware store would not sell a rain barrel that was illegal to use. The hardware store sells the barrel because the barrel is legal to own. The hardware store does not sell you a legal opinion about how you can use it on your specific parcel under your specific state's water doctrine. That is your job. The barrel is the easy part. The compliance is the hard part. The right move is to look up your state's water rights framework, identify whether your state operates under prior appropriation or riparian doctrine, and then read the specific residential collection statute if one exists. The science here is not hydrology. The science is statutory interpretation. Every state will have a state engineer or a Department of Natural Resources that publishes a plain language guide to residential rainwater collection. Read it before you set up the barrel, not after. Now, the multiplier on this category is interesting because the moment you start thinking like a person who reads statutes instead of a person who watches gear reviews, your entire prepping changes. The same skill that lets you legally collect rainwater in your jurisdiction also lets you understand gray water reuse rules, well permitting, and septic regulations. Water literacy is not just about the barrel. It is about every drop that enters or leaves your property. The same statutory reading muscle applies across all of it. One muscle, 5 different problems solved. But water is just the first room in the basement. The next category is the one that puts more law-abiding preppers on the wrong side of a misdemeanor than any other, and almost none of them know they are there. Ammunition storage. Here is where the picture gets uncomfortable, because I am going to walk through specific state statutes and specific federal adjacent regulations, and I want you to understand from the start that I am not talking about the lawful possession of firearms or ammunition in the abstract. I am talking about quantity, location, registration, and storage method. Those 4 variables are where the legal exposure lives. And every single state has a different set of rules. California Penal Code Section 30,342, along with the broader regulatory framework codified after the passage of Proposition 63 and subsequent legislation, established a regime in California that requires ammunition to be purchased through licensed vendors, that requires background checks on ammunition purchases, and that creates specific record-keeping and reporting obligations for transactions above certain thresholds. Beyond the purchasing rules, California also has localized storage requirements that vary by city, and several California cities have passed ordinances regulating the storage of ammunition in residences, including requirements for locked containers and specific safety protocols. If you are a California resident who relocated from another state and brought a stockpile of ammunition with you, you have a paperwork problem the moment you cross the state line. And the longer you wait to address it, the worse it gets. The statute does not have a built-in amnesty for people who arrived with legally purchased ammunition from another jurisdiction. It just has the rules. The New York SAFE Act, passed in 2013, established additional restrictions on ammunition sales, registration, and capacity that have evolved through subsequent court rulings and legislative amendments. The original act included provisions on background checks for ammunition purchases and limits on certain magazine capacities. Some provisions were modified or struck down through litigation. Others remain in force. The net result is that a New York resident who follows the Prepper Influencer playbook and stocks up on standard capacity magazines purchased online from an out-of-state vendor is potentially looking at multiple violations under state law, none of which the influencer mentioned in the gear review. New Jersey has its own framework, with specific magazine capacity limits, transportation rules, and storage requirements that are aggressive even by Northeastern standards. The New Jersey statutes treat certain ammunition components and certain magazine capacities as regulated items, and the penalties for violations are not minor. New Jersey has prosecuted residents and non-residents alike for transporting items through the state that would be entirely legal in their state of origin. The classic case involves an out-of-state resident driving through New Jersey with a properly stored, lawfully purchased magazine of a capacity that exceeds the New Jersey limit. The driver is not threatening anyone. The magazine is in a locked case in the trunk. The driver gets pulled over for a routine traffic stop. The officer asks about the contents of the trunk, and the driver, attempting to be cooperative, mentions the case. The next step in that story is rarely a warning. Illinois operates the FOID system. The Firearm Owner's Identification Card under the Illinois FOID Act. Without a valid FOID card, an Illinois resident cannot legally possess firearms or ammunition in the state. The card has renewal requirements, address update requirements, and specific compliance obligations that can lapse without the holder noticing. There have been residents in Illinois who accumulated ammunition over years, allowed their FOID lapse, and discovered years later, sometimes during an unrelated interaction with law enforcement, that their entire collection had been technically unlawful for the duration of the lapse. The state did not send them a renewal warning loud enough to break through the noise of daily life. The state does not have to. The obligation to maintain compliance is on the holder. Beyond state-level statutes, there are also model fire codes that apply to ammunition storage in residences. And these codes get adopted by states and municipalities in varying forms. The International Fire Code, in editions adopted across most of the country, contains provisions on the storage of small arms ammunition in dwellings, and while the residential thresholds are generous in most jurisdictions, they are not infinite. A resident who has consolidated a large stockpile in a single closet, in original cardboard packaging, without any fire-rated container, may be operating outside the storage standard their local fire marshal would actually enforce in the event of an inspection. Inspections happen most often after an unrelated incident, a kitchen fire, an insurance claim, a neighbor complaint. The inspection finds the stockpile. The stockpile becomes a separate paperwork problem on top of whatever brought the inspector to the door. The right move on ammunition is identical to the right move on water. Read the statute in your state. Read the municipal ordinance in your city. Read the storage standard your local fire code references. Match your practice to the highest standard of the three. Document your purchases. If your state requires registration or background checks, comply. If your state has magazine capacity limits, know them. If you travel across state lines, plan the route in advance and understand that the rules change at the state border, not at the destination. A magazine that is legal in your home state can be a felony in the next state over, and the highway between them is full of officers who know the rules better than you do. I want to introduce a voice here, because at this point in the episode, you should be hearing from someone who lives this question for a living. Daniel Yarborough is a defense attorney with a Second Amendment practice based in the Mountain West. I have read his published commentary in several legal journals, and the line of his that has stuck with me is this: the average gun owner spends more time researching their next purchase than they spend researching the laws that govern it, and the courts do not grade on effort. That sentence is the entire category in one breath. The courts do not grade on effort. You either complied or you did not. The deputy at your door does not care how many hours you spent watching gear reviews. So that is category 2. Now we walk to the back wall of the basement where the gas cans are. Category 3, household fuel storage. This category is the one that most preppers absolutely refuse to take seriously, and it is the one that most consistently produces actual enforcement contact. Usually through fire marshals and insurance inspectors rather than sheriffs, but the mechanism is the same. The federal adjacent framework here is NFPA 30, the Flammable and Combustible Liquids Code, published by the National Fire Protection Association. NFPA 30 is not itself law, it is a model code. But here is the trick of model codes. They get adopted by reference into state fire codes and municipal codes across the country, and once adopted, they have the force of law in that jurisdiction. Most states have adopted some edition of NFPA 30, or the related International Fire Code provisions that mirror it, into their state fire marshal regulations. The result is that a code written by a private standards organization becomes binding on you the moment your state adopts the addition. What does NFPA 30 actually say about residential fuel storage? The specifics depend on the addition adopted in your state, but the general framework draws lines based on the type of liquid, the container, and the total volume. Class 1 liquids, that includes gasoline, have the strictest residential limits. Most adopted versions cap residential gasoline storage at relatively modest volumes, with specific requirements for approved containers, ventilation, and distance from ignition sources. Class 2 and Class 3 liquids, that includes diesel and most heating fuels, have more generous limits but still have ceilings. The point is not to memorize the exact numbers tonight, because the numbers vary by addition and by jurisdiction. The point is to understand that there is a ceiling, and that ceiling is much lower than the romantic prepper fantasy of stocking hundreds of gallons of gasoline in the basement. Here is the typical mistake. A homesteader watches a content creator who lives in a rural state with permissive storage rules. The creator shows off a workshop full of red gas cans, racks of fuel containers, a wall of stacked drums. The viewer, who lives in a suburb in a state with a strict fire code, replicates the setup. The viewer is now operating outside the residential storage limit by a factor of 3 or 4, depending on the jurisdiction. Nothing happens. For years, nothing happens. Then a pipe leaks in the basement. The plumber comes. The plumber sees the fuel storage and reports it to the fire marshal. Or the homeowner files an insurance claim. Or a neighbor with a grievance makes a phone call. The mechanism does not matter. The result is the same. A fire marshal at the door, a notice of violation, and a deadline to bring the storage into compliance, often with a fine attached. In some jurisdictions, severe violations can be charged criminally, particularly if the storage is found to have created a hazard to neighbors. Beyond the volume, there is the container issue. NFPA 30 and its derivative codes specify what types of containers are approved for what types of liquids. Approved metal safety cans with self-closing lids and flame arresters. Approved plastic containers in specified sizes. The cheap red plastic 5-gallon cans you stack in the corner of the garage may or may not meet the current standard depending on when they were manufactured and what certification they carry. If a fire marshal walks into your storage area and sees containers without proper certification markings, the containers themselves are a violation, separate from the volume question. There is also the location issue. Fuel storage near ignition sources, water heaters with pilot lights, electrical panels, gas furnaces, is a layered violation. The fire code does not care that you intended to be safe. It cares about distance and barrier. If your fuel cans are within the prohibited distance of an ignition source, you are in violation regardless of whether anything has ever ignited. The right move here is again the same skill applied to a different room. Look up which edition of NFPA 30 or the International Fire Code your state has adopted. Most state fire marshal offices publish that information openly. Read the residential storage section. Compare it to your actual storage. Reduce volumes, upgrade containers, relocate ignition-adjacent storage, and document your compliance. The goal is not to abandon fuel preparedness. The goal is to be prepared in a way that does not generate a paper trail of violations the next time anyone with authority walks through your basement. Now I want to bring in a second voice, because the rural reality of this category is different from the suburban reality, and the difference matters. Sheriff Connor McKinley of Park County, Montana, has spoken publicly about how his department handles fire code and fuel storage issues in a rural jurisdiction. And his framing is useful. In a rural county, the sheriff's office is not running residential inspections looking for violations. They are responding to fires, accidents, and complaints. The enforcement contact happens after something else has already gone wrong. McKinley has made the point that the people who get into trouble in his county are almost never the people who took the fire code seriously. They are the people who treated the fire code as something that applied to other people. The same logic applies in suburban and urban jurisdictions. but the volume of complaint-driven contact is much higher there. In dense neighborhoods, your storage is not a private matter. It is a shared wall, a shared ceiling, a shared insurance pool. Your neighbor has standing to complain. The complaint triggers the inspection. The inspection triggers the citation. That is Category 3. We are halfway through the basement. 2 more rooms to go. The next category is the one most viewers think does not apply to them, and they are wrong, because it has migrated from rural homesteading into the suburbs over the last 15 years, and it has taken regulation with it. Urban poultry and small livestock. You may be thinking, Raccoon, I do not have chickens. This category does not apply to me. Stay with me, because this category teaches the most important lesson in the entire episode. The lesson is that municipal ordinance is the most active layer of regulation in your life, and you are almost certainly not reading it. Federal law moves slowly. State law moves seasonally. Municipal ordinance moves every council meeting. The city council in your jurisdiction passes new ordinances regularly, modifies existing ones, and rewrites the zoning code in ways that affect your property. Almost no resident reads the agenda for those meetings. The result is that the legal landscape on your own block changes more often than you change your air filter. Urban poultry is the case study that proves the rule. Over the last 15 years, cities across the country have moved in 2 directions on backyard chickens. Some cities legalized them under specific permit and setback regimes. Other cities tightened restrictions or banned them outright. Houston, Detroit, and Atlanta have each gone through public regulatory cycles on this question, with ordinances that specify the number of birds allowed, the distance coops must be from property lines, the prohibition on roosters in many districts, and the permit fees for keeping any poultry at all. The same kind of ordinance applies in many cities to rabbits, ducks, and other small livestock, sometimes more permissively, sometimes less. Reason Magazine, the publication of the Reason Foundation, has published extensive reporting over the years on urban regulatory creep, including specific case studies of homeowners who faced enforcement action over chicken coops they believed were legal. The journalist Theresa Whitlock has covered this beat in particular, documenting cases where residents complied with what they understood to be the rule, only to discover that an amendment passed 2 years prior had changed the setback requirements or the permit ceiling. The pattern she documents is consistent across cities. The resident reads the ordinance once, sets up the system, and stops reading. The city amends the ordinance. The resident is now out of compliance and does not know it. A neighbor complains, often over an unrelated dispute, and the complaint becomes the entry point for code enforcement. The lesson here is not specifically about chickens. The lesson is about the muscle of reading municipal ordinance. Every category we have covered tonight, water, ammunition, fuel, has a municipal layer on top of the state and federal layers. Your city has a fire code on top of the state fire code. Your city has a noise ordinance, a setback ordinance, a structure ordinance, a nuisance ordinance. Every one of those ordinances is amendable at any council meeting. If you are not reading the agenda, you are not informed. You are guessing. Guessing is not a defense. The right move here is to subscribe to your city's council meeting agendas and your county's commissioner agendas, and to scan them when they arrive. You do not have to read every line. You scan for keywords related to your interests: water, fire, animal, weapon, transmitter, structure, zoning. You spend 15 minutes a month on this. It is the cheapest legal insurance you will ever buy. Most cities now publish agendas through their websites and offer email subscriptions. The sign-up takes 2 minutes. The ongoing time investment is trivial. The consequence of not doing it is the same consequence we have been describing all night. You become a violator without knowing it. Theresa Whitlock's reporting also surfaces a second lesson that I want to highlight, because it is the lesson that connects this category to all the others. Code enforcement in most cities is overwhelmingly complaint-driven. Inspectors do not roam the streets looking for violations. They respond to complaints. That means your exposure is a function of two things: whether you are technically in violation and whether anyone has reason to call. The technical violation is the legal question. The complaint is the human question. You can reduce the technical violation by reading the code. You can reduce the complaint risk by maintaining good relationships with neighbors, keeping your property visibly tidy, and not advertising your preparedness in ways that invite curiosity. Operational discretion is not paranoia. It is the recognition that the second variable is just as important as the first. So that is Category 4. Now we move to the last room, Category 5, the one with the most aggressive federal enforcement record: unlicensed radio transmitters. This is the category that catches preppers who think they are the most prepared because radio communication is genuinely critical in any prolonged grid down or infrastructure disruption scenario, and serious preppers know it. The community has, for decades, encouraged radio literacy, the acquisition of equipment, and the practice of communication. All of that is good. The problem is the gap between owning a radio and operating it lawfully. The Federal Communications Commission is the federal agency with jurisdiction over the radio spectrum in the United States. The FCC Enforcement Bureau is the unit that pursues violations. Their enforcement actions are public, and you can read the quarterly reports on the FCC's official website. The reports are an education in themselves. Every quarter, the FCC issues forfeiture orders, notices of apparent liability, and consent decrees against operators who transmitted on bands without proper licensing, who modified equipment in ways that exceeded authorized power output, who implement must be lawful to operate without further qualification. That is not how the FCC framework works. The equipment is one thing. The operator authorization is another. The General Mobile Radio Service requires a license. The Amateur Radio Service requires a license, with multiple class levels, each authorizing different bands and privileges. The Family Radio Service is license-free, but has strict power and equipment limitations that many imported handhelds violate. Citizens Band Radio is license-free, but has its own power and modification rules. Marine and aviation bands have their own restricted use frameworks. The Multi-Use Radio Service has specific channel and power rules. Each service has a different rulebook, and the rulebooks are not interchangeable. Beyond the licensing question, there is the equipment authorization question. The FCC requires that equipment marketed for use under specific services be type accepted or certified for that service. A handheld transceiver imported from overseas that is sold online for under $30 may be capable of transmitting across multiple services, including services for which it is not type accepted. Operating that equipment outside its authorized service is a violation of the equipment rules, separate from the operator licensing question. The FCC has, in recent years, issued explicit guidance on certain widely available imported transceivers, warning operators about the legal limitations of using them for transmission on services for which they are not certified. Many preppers own these radios and have never read that guidance. The third variable is power output. Even within a service for which the operator is licensed and the equipment is authorized, exceeding the authorized power output is a violation. Modifications that increase output, the use of amplifiers beyond the authorized scale, and the use of antennas in configurations that effectively boost radiated power above the limit can all generate enforcement contact. Direction-finding technology has advanced significantly, and the FCC, often working with cooperating amateur radio enforcement volunteers and licensed operators, can locate the source of an unauthorized transmission with precision that surprises most violators. So what is the right move? The right move is to treat radio the way a serious operator does. If you are committed to communications preparedness, get the actual license for the service you intend to use. The Amateur Radio Technician Class license requires a 35-question multiple-choice exam. The question pool is published in advance. Free study materials are widely available, and the exam fee is modest. The license, once earned, gives you lawful operating authority on a meaningful set of bands and the right to use significantly more capable equipment than the license-free services allow. Beyond the technician class, the general and extra class licenses unlock additional bands and global communication capability. For non-amateur services, follow the licensing path appropriate to the service. The General Mobile Radio Service License is straightforward and inexpensive and covers an entire family. Get the license. Use type-accepted equipment for the service. Operate within authorized power. Document your equipment and your authorizations. The cost of compliance in this category is by far the smallest of any category we have covered tonight, and the cost of non-compliance, given the active enforcement record of the FCC, is by far the largest in raw dollar terms. The asymmetry is enormous. Comply. Now, having walked through all 5 categories, let me bring them together because the synergy is the part most viewers miss. Each category is a single line item, a single misdemeanor, or a single civil penalty. Annoying, expensive, but survivable. The danger is the synergy. When a prosecutor or a code enforcement officer encounters a property where multiple categories are out of compliance simultaneously, the framing changes. You are no longer a homeowner who made an error in one area. You are now a pattern. You are a person whose conduct demonstrates a disregard for multiple regulatory frameworks. That framing changes how charging decisions get made, how negotiations proceed, and how a judge reads the case if it goes that far. 2 violations is 2 times as bad as 1. 3 violations is more than 3 times as bad as 1, because the 3rd violation establishes pattern. Pattern is the prosecutor's favorite word. The honest estimate, drawn from the cumulative reporting in this space across the journalists who actually cover it, is that something like 80% of self-identified preppers are operating with at least 1 technical violation across the 5 categories we discussed tonight. Most have not been contacted by enforcement. The contact is a low probability event in any given month, but low probability events accumulate over time. And the trigger for contact is rarely something you can predict. A house fire, an insurance claim, a divorce, a neighbor dispute, a traffic stop that escalates, a welfare check on an elderly family member. Any of those events can become the entry point. The compliance work you do in advance is the only thing that determines what they find when they walk through. Here is your weekend audit. I want you to do this in the next 7 days. Set aside 1 Saturday morning. Pour your coffee, walk down to your basement or your storage area with a notebook. Go category by category. Water. Read your state's residential rainwater collection statute. Note your jurisdiction's specific volume limits and registration requirements, if any. Compare to your current setup. Document. Ammunition. Read your state's storage and capacity statutes. Read your municipal ordinance if one exists. Read the fire code residential limit on small arms ammunition. Match your storage method, container, location, and total volume to the highest applicable standard. Document. Fuel. Identify which edition of NFPA 30 or the International Fire Code your state has adopted. Read the residential section. Inventory your containers, volumes, and locations. Verify container certification markings. Reduce, relocate, or upgrade as needed. Document. Animals and structure. Read your municipal ordinance and your zoning code for any small livestock, structure, or accessory building rules. Subscribe to your city council and county commission agendas. Document your current setup against the current ordinance. Radio. Inventory your transceivers. Identify the service each is type accepted for. Identify the license required for each service you intend to use. If you are operating without a license in a service that requires one, stop transmitting until you have the license. Schedule the exam. Document your equipment and your licenses. 5 categories. 1 Saturday morning. A notebook full of notes by lunchtime. A list of fixes by dinner. a weekend of work to bring the property into compliance spread across the next month. Total cost, in most cases, under $500. Some categories cost nothing but time. The radio license costs less than dinner for two. The fuel container upgrade costs less than a tank of gas. The work is small. The protection is large. Now I am going to close with the part that actually matters, the part that is bigger than any single category. The lesson under the lesson. The survival industry has sold a generation of viewers a fantasy in which preparedness is a function of gear. Buy the gear. Stack the gear. Display the gear. Review the gear. The gear is the product. The gear is the content. The gear is the identity. And the gear sells because gear is photogenic and ordinances are not. Statutes do not generate thumbnail clicks. Code sections do not trend on social media. The literacy that actually keeps you out of a courtroom is the least marketable skill in the entire space, and so it is the skill the industry has trained you to ignore. I am asking you to ignore the industry on this point. The deputy at the door does not care about your gear. The deputy cares about the statute. The judge does not care about your followers. The judge cares about the code section. The insurance adjuster does not care about your prep. The adjuster cares about the fire code edition adopted in your jurisdiction. Every adult in the system who has authority over your outcome is operating from a written rulebook. You either read the rulebook or you do not. The reading is the work. Everything else is theater. And here is the harder truth. This same chain, federal declares, state applies, county knocks, does not stop at the 5 categories we covered tonight. The chain is active in every domain that touches your preparedness. Vehicle modifications, off-grid power systems, water well permits, food preservation and home processing, land use and accessory dwellings, drone operation, encrypted communications, cross-border travel with regulated items. Each domain has its own federal, state, county chain. Each chain produces its own regulatory tide. Each tide moves on a schedule that is not yours. The skill of reading the rulebook is not a one-time skill. It is a permanent practice. You do not finish it on Saturday. You start it on Saturday, and you continue it for the rest of your life as a serious adult who is responsible for the outcomes on your own property. The crowd will not do this. The crowd will keep watching gear reviews. The crowd will keep believing that the rain is theirs because the rain fell on their roof, that the ammunition is theirs because they paid for it, that the fuel is theirs because the hardware store sold it to them, that the chickens are theirs because the coop is in their yard, that the radio is theirs because the box arrived at their door. The crowd will be wrong, in part, in some jurisdiction, on some Tuesday, when the chain reaches their door. And when the chain reaches their door, they will say what every uninformed defendant has said since the beginning of the modern administrative state. They will say, "Nobody told me." The court will respond the way the court always responds. The court will respond that the law was published, that the publication was sufficient, and that the obligation to read what was published belongs to the citizen. You are not the crowd. You are watching this episode. You are about to do the audit. You are going to read the statutes. You are going to subscribe to the agendas. You are going to get the license. You are going to upgrade the container. You are going to register the cistern. You are going to do the work that the crowd will not do. And the work will pay you back every single year for the rest of your life in courtrooms you never have to enter and citations you never have to negotiate. Know the code, or become the case file. That is the choice. That is the entire choice. And the next episode of Raccoon Survival is going to walk you down a different staircase into a different room of the same house, where another 5 categories are waiting for you, and where the chain has already been moving for years while you were not looking. We are going to talk about the federal, state, county chain in a domain most preppers have never even mapped, and we are going to name the bills, the codes, and the enforcement bureaus the way we did tonight. If this episode put a knot in your stomach, the next one is going to put two. Because the basement is just the basement, the garage is the next room, and the garage has its own rule book. The code did not stop, and neither did the knock. Until next time, audit your basement, read the statute, get the license, document the compliance, and do not, under any circumstance, let the next person who walks through your door be the one to teach you what was already written. Raccoon Survival, signing off.